If you've been subpoenaed to be in the, as a witness in this case, you'll need to leave the courtroom. And, all right.
Okay. Any witnesses here in the courtroom that have been subpoenaed to come? All right, thank you. Your Honor,
Before we start, Your Honor, the state had some matters they wanted to bring up here before we got started. I believe it was yesterday. Defense provided a jump drive that contained more than 1,000 pages of a report, modified report from their expert. I think it's late for providing that kind of information, especially in that
What
volume.
type of expert are you talking about?
It's the digital media expert, forensic expert on computers, and digital media. And if you recall, Your Honor, we had the state had requested, noticed an expert for the state. We had a hearing on that in Ripley, and we had provided a one page, basically a page and a half of what she was going to testify to. That was in that hearing in Tippah County. The court said it was, too close to the trial.
It was Tuesday of last week, Tuesday morning of last week, the state produced
November 5th or 6th, I believe, and provided an opinion that she was going to.
The substance of her testimony was provided Tuesday morning of last week, anyway, Tuesday before Thanksgiving.
About a page and a half.
when did we disclose? Your Honor, in response, I represent to the court, I think in our fourth supplemental discovery response, I believe we identified Mr. Coker as the witness almost a month and a half ago. And as the court recalls, I made some arguments previously about the fact that due to the late discovery getting the computers, we were in, or the computers from the Detective Baker, we were scrambling to get an expert. We got the expert, and then, of course, it's a lot of documents, a lot of things we had to look through, and he's basically going to provide a report to them in a condensed version.
Going to right now, have you got a report other than a 1,000-page report?
140-page report.
140-page report.
That was provided some time ago, I believe. The first report was provided sometime in, I think the Friday before we went to Ripley.
No, that was provided the day after the hearing. The 143-page report was provided the next day. Someone from their office came late that afternoon to the DA's office and hand-delivered it to me on that Tuesday.
Not, regardless of that, Your Honor, he was disclosed some time ago as to being the expert.
I don't know if I'm going to deal with this issue right now before the jury comes in, but I'm going to want to know what was disclosed when the disclosure was made. The disclosure on the state's witness, the disclosure, I believe it was made on state expert, made on November 6th, that we're going to be testifying, and it really wasn't much of a disclosure until a substance of their report was not provided until substance of their testimony until Tuesday before the trial to start on Monday. We got a jury sitting back there. I want to be figuring out what was disclosed to the state, when. Y'all be thinking about that. And then we'll deal with the issue that you've got, which is more pertinent to today's testimony.
We'll also provide to the court the time frame in which we got the information to send to the expert, which I think is relevant.
Y'all be studying on that, but that's not, I don't have to make a ruling on that matter to deal with our testimony we're dealing with today, and I may have some time this weekend for us to study on that. Okay, go ahead, Mr. Creekmore.
Your Honor, the other matter is Jeremy Rainey asked the clerk to see what subpoenas had been issued by the defense. And the deputy clerk printed out a series of documents that I would like to have marked for identification, just for purposes of this disclosure to the court.
You can mark anything for identification anyway. Let me get to where I'm at. That's going to be S43, is that right? Ricky, if you would tell the jury that we promise we're out here working, but we're going to be a little while, okay?
That's 43. Appears to be a number of subpoenas that were issued back in August, I believe August 15th of this year, in blank. Since then, we have had several officers that have been served with subpoenas from the defense that appear to be from that type of a batch.
Let me say this. I'm going to ask the assistant. Has defense provided the witness list?
We have.
Is there anybody was anybody served with a subpoena that's not on the witness list?
I don't know, Your Honor.
I don't either.
I think maybe one or two.
Well, let's find.
Hold on.
Okay. And then that could be some rebuttal evidence or something. But well, you want. I don't know about rebuttal on the defense part.
That's what. Your Honor, can I just?
Yeah, go ahead.
We supplemented discovery with a number of witnesses. Every time we've done supplemental responses to witnesses, my understanding is the court's ruling that, correct me if I'm wrong, that providing the discovery list to us the night before trial was not a discovery violation, nor was there a discovery violation in providing the list on 11/21 of this year. So it's the ruling of the court that the state doesn't have to provide a discovery list of the discovery violation, and the defense does?
I hadn't ruled anything.
I understand.
I haven't ruled anything. I have cited it. We're deep enough into this trial that if you're going to call a witness, the other side needs to know who it is.
Some of those witnesses I don't know until they get done. Everybody that we have subpoenaed or issued subpoena for, other than those that listed on our discovery, is in the 22,000 pages of discovery that they provided us. Fair enough?
No. Even though it may be late, the state has provided you with the witness list, even though it's late. And I expect the same out of the defense. If you've got somebody suspended that you expect to be called as a witness in this matter, the state needs to know who that witness is.
I represent to the court that everybody that we've issued subpoenas for at this time was on our discovery. I cannot represent to the court until such time as the state moves forward with their case. I may, as soon as I know that this witness is off of my list, I'll provide it to them once I issue a subpoena for them. But I don't anticipate that being the case.
Once you,
We've supplemented our discovery with witnesses 5 times prior to the commencement of this trial in an effort to comply with the rule. We thought complying with the rule. The first one we got was a week before trial.
I don't want to interrupt, but I don't think the rule allows for the circuit court to issue subpoenas in blank and hand a cache of subpoenas to a lawyer that they can just write whoever they want to.
You better read the rule.
I think it probably, in, the new rules don't even require the clerk to issue issue the subpoenas that the attorney, at least in civil proceedings, that to.
It's correct.
And I don't know if that applies to criminal proceedings or not. That the attorneys are authorized to issue their own subpoenas.
That's correct.
I haven't been presented with that situation yet, and it's a brand new rule anyway, so I'm not up to date on it. But I do believe the Supreme Court authorized attorneys to issue their own subpoena without the necessity of even going through the clerk's
That's exactly right.
I do want to look at that rule and see if it applies to the.
It also provides for issuing subpoenas in blank. That has not changed. But nonetheless, Your Honor, I'm representing to the court that everybody, if there's a witness outside of what we've already disclosed, they will be timely notified when I know about it. They gave me a witness statement during the course of this trial that was untimely. We hadn't gotten to that yet. But, Your Honor, I understand what the rule is on disclosure. I've been complying with it up to this point in time, and I anticipate I will moving forward. There's nothing wrong with what he's introduced in the exhibit.
I believe under the new rules that, and I just happen to remember that. I think it's been the last, maybe effective July the 1st, I think it was. That the clerk doesn't even have to issue subpoenas, that the attorneys are authorized to do so. I've seen somebody pulling out a rule book there. That may not even be a new enough rule book, but I think it just has become effective.
Your Honor, but
I'm going to expect all parties, when they know they're going to call a witness, if that witness has been identified in the discovery, you'll have some more leeway.
sure.
If it's not somebody that's coming out of the woodwork, don't be surprised if they don't.
We don't have any squirrel hunters, Your Honor.
Hang on, I see y'all looking at the rule there now anyway.
Your Honor, just for the record, 45A clearly says that the clerk can issue subpoenas in blank to a party requesting it. And that's what those are in blank.
I think that's right, and I believe as of July the 1st, and the clerk may want to take notice of this. Look at the new rules anyway. I think you can tell the lawyers, go issue your own subpoenas. We busy today.
We'd like to know about it when they do.
Do what now?
We would like to know about it when they issue the subpoena for signing.
And Judge, we ask the same when the state is under seal of the sentence of capital. We'd like to know about it.
All right, we're gonna.
Judge, I think
At this point, I've found no violation of the rules by the issuing of the subpoenas in blank. If a witness is discovered late, I'll deal with them on an individual basis.
Thank you.
We'll cross that bridge when we get there anyway. But I'm telling everybody, if you're gonna call somebody as a witness, tell the other side.
fair enough.
All right.
Your Honor,
You started on your corpus delicti.
yes, Your Honor, motion in limine at this point in time to preclude the state from moving forward on any other proof pertaining to evidence extraneous outside the scope of any, not necessarily outside the scope, but out as far as being relevant. The court ruled earlier that the relevancy as to what transpired here in Lafayette County as to some of the stuff over the defendant's objection. My understanding is that the state anticipates placing into evidence witnesses from Grenada pertaining to a box truck that has apparently, according to the state and understand through the course of discovery, could be deemed relevant should the proper predicate haven't been laid. At this point in time, the court has been very lenient on the state as far as, you know, like the court said the first day, let's get started somewhere. And understand that's what they did. They were to establish that there was a missing person report, establish that the last person that talked to him, or at least the last person that may have talked to him, was at least our client. That's as far as we've gotten, Your Honor. Now I understand they want to head to Grenada and start introducing videos in Grenada without any connection to any crime or anything whatsoever. The problem that is created for the defense, Your Honor, as far as, you know, objected constantly on grounds of relevancy, and the court has been very liberally in its approach to allowing the state to introduce conversations between apparently our client and the alleged deceased, and allowed to do so over our objection as to hearsay, objections to relevancy, all those things. That at this point in time, there's been no connection to any evidence of a crime having been committed. All we've got right now is somebody talked to somebody on the phone. It was seen apparently in close proximity to the individual's car. Your Honor, at this point in time, under Pitts versus State, which is a real old case, 43 Mississippi 472, two things that have to occur before you go forward on a homicide case, in all cases really. First of all, when it pertains to homicide, you have to prove the fact of a death. Second is the existence that there's some criminal agency that caused that death. And it states in there the former must be proven by direct or presumptive evidence, but the latter must be established by circumstantial or presumptive evidence. And that's the order in which they have to do that, Your Honor. We've gone kind of
Back up on that. The first being that there were the two elements, one of them direct or run over that statement there with me again anyway. Hang on, let him have his say and I'll give you yours.
It's a whole case. Basically, it says first is the fact of death. The former must be proven by direct testimony or presumptive evidence of the strongest kind.
What is the first?
Fact of death.
Fact of death. Okay, go ahead.
Must be proven either by direct testimony or the presumptive evidence of the strongest kind, but the latter may be established by circumstantial evidence or by presumptive reasoning upon the facts and circumstances of the case. It also states that a dead body or its remains having been discovered and identified as the person charged to have been killed, and the basis of the corpus delicti being thus fully established, the next step in the process and the one which serves to complete the proof of that indispensable preliminary fact is to show that the death has been occasioned by the criminal act or agency of another. Prove a death, then you prove criminal agency. And we court allowed them to go forward with, in this case, by just doing the missing person, conversations, things of that nature, videos over our objection. And our position is, Your Honor, that should not have occurred And it's also putting us in a situation where when we're objecting to certain evidence as being hearsay or things of that nature, and the court says, well, these are conversations between these two individuals and other individuals. Well, on the grounds of relevance, anything in all this pile of exhibits here ought to be relevant. We shouldn't be discriminating as to whether or not a conversation that was 2 weeks earlier between Jay Lee and some other guy is too remote in time, because we don't know if it's too remote in time or not, Your Honor, based on what they presented. The manner in which they presented their case, it should not be any reservation for this court to say, get it in. Any conversation. They're asking the court to make determinations on what's relevant as to what occurred on the date in question by virtue of the fact, because asking the court to make quantum leaps as to whether or not anything occurred and proof moving forward. That's basically what they're doing. It's just like a 911 call. When you get a 911 call, someone says, well, someone's hurt at a house. The next proof is we're going to put into evidence there's a gun somewhere and say, this is not the way you try any case, Your Honor. You can't do that. You have got to prove corpus delicti in a fashion that is done. Prove that there is, in this particular case, a death, and circumstantial evidence or direct evidence that supports that there's some criminal agency that caused that death. What evidence of criminal agency have they put on at this point in time to allow this proof to come in about things that have occurred in Grenada County? What evidence have they put on to support any of the videos that they've introduced at this point in time? Nothing. They got a missing person. I understand that. His car's driving through town. Very confusing to the jury at this point in time. But what put us in a bind, Your Honor, is when we approach the rail and we say we're arguing about exhibits 31 through 37 and whether or not this officer can testify about this report. None of those objections should in any way, shape, form, or fashion even come close to being granted, because the court has no information as to what's relevant moving forward. Your Honor, we just need at this point in time to get back to Oxford and let them put some proof on at this point in time that there is a crime that's been committed before we drive back down to my neck of the woods and start putting videos on. That's not asking too much, Your Honor, to follow the law. And you did say the first day we got to start somewhere, and we did. But now's the time for us to stop it. And I don't think we should have started it in the first place, but now's the time to stop it, John.
All right, I'll hear from the state.
John, I have a number of cases on corpus delicti. Laws basically the same last 200 years.
All right, go ahead.
Yes, Your Honor. It was honestly very hard to follow defense counsel's argument because it was nonsensical. I will say that the defense cannot tell the state how to put on their case. Corpus delicti is, first you have to prove that there was a death and that the fact of the death, that someone has died. That's element one. And element two is that that person died as a result of a criminal action, criminal agency. None of that case law tells you the order in which you have to prove it. It does not say that. The case law just says there's two elements to corpus delicti. It does not say, oh, you have to prove this and then you have to prove this. I too have read all the cases in Mississippi on corpus delicti, and it does not say that. You could, if you want to interpret it in that way because it says there are two elements, then you can. But as defense counsel, he is correct in saying that the first element of corpus delicti, a death, it is proven by either one, direct testimony, or two, presumptive evidence of the strongest kind, which can also just be circumstantial evidence. The second element of corpus delicti can be proven by circumstantial evidence as well. Your Honor, all of this, obviously we do not have a body in this case. Obviously, because of that, we're proving a circumstantial case. Your Honor, to say that it's remote in time as to messages with Jay Lee from 2 weeks ago, we know he was still alive based on the proof. We know he was still alive back then. So if you say those messages, how are they? They are remote. He wasn't killed 2 weeks prior to this. His digital footprint stops after he went to Tim Herrington's home. The evidence that's come forward right now, Your Honor, is that Tim Herrington invited him over to his house, his apartment. That right before he got there, Tim Herrington Googled, how long does it take to strangle someone? That Tim Herrington is presumed to be the person who's dropped Jay Lee's car off at Molly Bar Trails. That Jay Lee did not give anyone rides in his vehicle. That Jay Lee's abandoned his dog. That Jay Lee's accounts haven't been touched. That Jay Lee, since he last texted Tim Herrington, that the last text that Jay Lee ever sent was open to Tim Herrington. That is what's come forward. And that the last person who has ever seen Jay Lee alive is Tim Herrington. Grenada comes in as to criminal agency because what we will find out as this case goes on, that the same day after Tim Herrington dropped off Jay Lee's car at Molly Bar Trails and pretended like he had been running that whole time and was picked up by Tyson King, he then got his box truck from his moving company and went to his parents' house, didn't drop anything off, and put shovels and a wheelbarrow into his box truck. To say that that is not proof of death or circumstantial evidence related to death is bears belief. It's bizarre. Your Honor, the defense counsel wants to make corpus delicti that says you have to prove this first and this second. The case law says you have to prove the elements of corpus delicti for a homicide. The elements of corpus delicti. That's what you have to prove. The state is in the process of proving that. We have laid out evidence where Jay Lee could be found by this court and by a juror to have been killed, that Jay Lee, and it could have been by way of criminal agency. And we're still in the process of presenting our proof, Your Honor. We haven't even finished. But to say we have to present it in the order that defense counsel would like us to present it in is, there's no case law in Mississippi that says that. We get to put on our case. Further, I would say, Your Honor, that this entire thing with the witnesses from Grenada, the truth is that they wanted to exclude all of our witnesses based on, or all of our evidence, because they know it's of guilt of their client based upon procedural issues, because they didn't think that we would be able to get all these people in here to testify. Now that we have them, now that they're coming in to testify, to authenticate and all these videos, now there's another problem. Well, if that was always a problem, why didn't you file that motion in limine before trial? Oh yeah, because it's not about that. Because you really want to do this because you know that makes your client look even guiltier. And that's what's going on here.
All right. I'll give you a chance to respond.
His case lays out basically what you have to do.
I've read the Pitts case while I've been here.
Yeah. The next step in the process is complete the proof. I don't know what I missed in this particular trial, but I heard the officer testify that the phone was pinging at a location away from close to Stone Park. That's no evidence that Jay Lee has perished. There's no criminal agency been established at all, Your Honor. All this stuff about the notice of intent, all this stuff is irrelevant to what the court has got to do here.
Thank you,
If I remember correctly, Your
Your
Honor,
Honor.
defense counsel said that.
I'm familiar with your arguments anyway.
Your Honor.
Court's ready to move. The Pitts case back a long time ago, 1870, I think, October of 1870, says two fundamental elements of corpus delicti. First, the death must be proved by direct evidence. I take direct evidence of there's a body, or presumptive evidence of the strongest kind. Courts of the opinion, when the mother, who was the first witness, got through testifying, that she talked to her son several times a day. He always talked to her on Mother's Day. She's not heard from him. He left his dog. He's been no account activities, active on social media, and he has not been heard from since July the 8th of 2022. That is presumptive evidence of the strongest kind of a death. I think that element to a reasonable juror could be found as soon as the mother got through testifying. So the court's going to find that, to the court's satisfaction, that there has been presumptuous evidence of the strongest kind of a death. We've had that testimony in this case, and the criminal agency may then be established by presumptive reasoning upon all the facts and circumstances of the case, i.e. circumstantial evidence. And the state has set about offering circumstantial evidence of the criminal agency in this matter. I think that the state has put on sufficient evidence at this time to warrant the introduction of additional information on the evidence of criminal agency and death. I think that I'm not so sure about when all this has to occur, but the court is finding that there have been presumptive evidence of the strongest kind of a death in this matter, and I'm going to let the state continue to put on its circumstantial evidence of criminal agency, and that's so. I've heard your objections, and the court's going to make that ruling. All right. Are we ready for our next witness?
Yes, Your Honor.
All right. Let the court take just a couple of minute breaks, and then we'll get started.